Hello and welcome to your ultimate guide for the Ohio Real Estate Salesperson exam. My goal today is simple. Give you everything you need to fully understand the key concepts, master them, and walk into your exam with total confidence. In this video we'll cover regulatory structure, disciplinary process, recovery fund, license requirements, license maintenance. With over 100 plus success stories, we have proven our videos will help you pass your exam on the first attempt. And remember, our website offers free exam guides and practice questions to help you ace your exam. You'll find the link in the description below, so be sure to check it out and get the resources you need to study smarter, not harder. So let's get started.
Let's start with how Ohio governs the real estate profession, because who holds which power is tested directly. Ohio uses a layered structure, and the exam loves asking which body does what. The most important idea is the split between enforcement and rulemaking. See that split clearly and questions become easy points. At the top sits the Ohio Department of Commerce, the cabinet-level department that houses real estate regulation and provides the budget and oversight framework. Inside it is the Division of Real Estate and Professional Licensing. The division is the workhorse. It processes applications, issues licenses, investigates complaints, audits brokers, and brings disciplinary cases day to day. Leading the division is the Superintendent of Real Estate, the executive officer who runs the division and the Commission's administrative work. The Director of Commerce designates an employee of the department to serve as superintendent. The superintendent investigates complaints, reviews audit findings, issues the formal notice of hearing, and can even subpoena records and witnesses. Now, meet the Ohio Real Estate Commission, a separate 5-member body with a very different job. The Commission makes the rules, adopts the Canons of Ethics, and hears appeals from the superintendent's disciplinary decisions. Think of it as the legislature and Court of Appeals rolled into one. Proposed rules pass a formal review, giving lawmakers oversight. Here's a fact you must memorize. The Commission has exactly 5 members, appointed by the governor with the advice and consent of the Senate. 4 must have been licensed real estate brokers for the 10 years before appointment. The 5th represents the public with no real estate connection. They serve staggered 5-year terms. Now, here's the part most students miss, so listen closely. When a question asks who investigates a complaint, audits a broker, or issues a license, the answer is the superintendent or division. When it asks who adopts the Canons of Ethics or hears a discipline appeal, the answer is the Commission. Enforcement versus rules and appeals. One more body to keep separate. Ohio regulates real estate appraisers through a different group, the Ohio Real Estate Appraiser Board. Federal law requires appraiser regulation to stay separate from licensee regulation. So this board has its own standards. Don't confuse the Commission with the Appraiser Board. The Commission handles brokers and salespersons only. Here's a memory trick for the whole structure. Picture a house. Commerce is the house. The division lives inside doing the hands-on work. The superintendent leads the division and investigates. The Commission stands beside them as rulemaker and judge. Commerce houses, division works, superintendent investigates, Commission rules and judges. That answers many questions. What we just covered is exactly the kind of material in our free practice question bank. These aren't basic questions either. They're written to test your real understanding of who holds which power, just like the Ohio State exam will. Go try a few afterward and watch how quickly the structure locks into memory. Now let's move to discipline, starting with audits. The superintendent and division have authority to audit and examine a brokerage's books, records, and especially its trust accounts. This matters because trust account problems are among the most serious findings in all of Ohio license law. Knowing what gets audited and what follows earns real points. An audit usually covers all trust account ledgers, every transaction file for listings, purchase agreements and leases, agency disclosure statements, advertising materials, and the broker's agreements with affiliated salespersons. Audits can be random, checking a percentage of brokerages on schedule, or complaint-driven. Trust account shortages and commingling are the findings examiners care about most. Here's a number to lock in. Ohio brokers must keep transaction and account records for a set period, generally 3 years, and trust account records must reconcile on demand. And here's the inside students miss. A broker who can't produce records or whose ledger won't balance faces discipline even if no money was ever stolen. Now let's walk the discipline process step by step, because the exam loves testing the sequence. Discipline follows Ohio's Administrative Procedure Act, the same due process framework most Ohio licensing agencies use. It starts with a complaint and anyone can file, a consumer, another licensee, a lender, or the public. The division can also investigate on its own. If the superintendent proposes discipline, the licensee receives a written notice. That notice must state the specific charges, name the exact law or rule allegedly violated, and explain the right to a hearing. It's usually sent by certified mail to the licensee's address on file. That's one reason keeping a current address is itself a duty. Here's the single most tested number in this section. After receiving that notice, the licensee has 30 days to request a hearing. 30 days, not 10, not 60. Request a hearing in time and you contest the discipline. Let the 30 days pass with no request, and the proposed discipline generally takes effect automatically. If the licensee does request a hearing, it's scheduled no earlier than 7 days and no later than 15 days after the request, unless both sides agree otherwise. At the hearing, the licensee may appear in person, be represented by an attorney, present evidence, and cross-examine witnesses. A hearing examiner often presides and recommends findings. After the hearing, a final adjudication order issues with written findings of fact and conclusions of law, stating exactly what discipline applies. If the licensee disagrees, they may appeal to the Court of Common Pleas, usually in the county where the hearing was held. The court checks for reliable, substantial evidence. Appeals go to state court. So what actually gets a licensee in trouble? The grounds for discipline are a long list, and you should recognize the big ones: misrepresentation, dishonest or illegal dealing, fraud, false promises, failing to account for others' money, commingling or converting trust funds, acting for two parties without consent, paying an unlicensed person, false advertising, fair housing violations, the unauthorized practice of law, and conviction of certain crimes. When a violation is proven, several sanctions are possible. The mildest is a reprimand, a formal censure that goes on your record but doesn't stop you practicing. Next is suspension, which temporarily blocks practice. The harshest is revocation, the full loss of your license. They can also impose fines and require extra education, often combined. One fine appears on the exam more than any other, so memorize it. For advertising violations, the division may issue a citation with a fine of $200 per violation, capped at $2,500 per citation. One slip might cost $200, but a whole citation tops out at $2,500. I know we're covering a lot of detailed rules, and you might wonder how to make these numbers and steps stick. That's exactly why I built those free practice questions. They let you work through discipline scenarios and timelines until the sequence feels automatic. Head to the link in the description and try the discipline set. Next is the Ohio Real Estate Recovery Fund, a favorite exam topic. The fund exists to protect the public. When a licensee harms someone through misconduct and that victim can't collect, the fund can compensate them. Real estate moves large sums through licensees' hands, so Ohio built the safety net, funded by the industry itself. Let's see how the fund stays full, because the numbers get tested. The money sits in the state treasury administered by the superintendent. If the balance drops below $250,000 on the 1st of July, the Commission imposes a special assessment of up to $10 per year on each renewing licensee. Now, who can claim from the fund? Here's the crucial requirement. A person must first win a final court judgment against the licensee based on conduct that violated the license law, like fraud or conversion. Then they must try to collect and fail. Only then may they apply. The fund is not insurance or an easy shortcut. Here are 2 facts you must carry into the exam. First, the fund's liability cannot exceed $40,000 for any one licensee. $40,000 is the ceiling. Second, when the fund pays on a licensee's behalf, that license is automatically suspended until they repay in full with interest. No separate hearing is needed. Now here's the trap that catches so many students. The $40,000 cap is per licensee, not per victim. Imagine one licensee defrauds 3 clients who win judgments totaling $90,000. The fund still pays at most $40,000 total for that licensee, and the 3 victims share it proportionally, per licensee, not per claimant. Let's lock the recovery fund numbers in with a quick chant. 40 to fix the harm, 10 to keep it warm, 250 sounds the alarm, $40,000 maximum per licensee, $10 yearly assessment, $250,000 is the refill trigger, and payment suspends the licensee until they repay with interest. Simple as that. Let's shift to a foundational question. Who actually needs a real estate license in Ohio? The law lists many brokerage acts: selling, exchanging, buying, renting, or leasing real estate for someone else. It also covers offering or negotiating deals, listing property, advertising. You do this work, managing rentals for others, and helping procure prospects. Deliberately broad. Here's the simple 2-part test that unlocks these questions. An act requires a license when it's done first for another person and second for compensation. Both parts must be present. And compensation isn't just a cash commission. It includes any fee, rebate, gift, profit, or benefit you receive or even expect. That makes the net wide. This brings up unlicensed assistants, a popular exam scenario. A brokerage may hire unlicensed assistants for administrative work, like answering phones, scheduling, and preparing marketing under supervision, but they may never independently show property, negotiate terms, or discuss offers with parties. A broker who lets them cross that line is disciplined for permitting unlicensed activity. Some people perform these acts without any license, and you should know the exemptions. Owners dealing with their own property are exempt, even selling for profit, as are their salaried employees. Court-appointed fiduciaries like executors, administrators, and guardians are exempt. An attorney, in fact, under a power of attorney is exempt, as is a licensed attorney doing legal work. To remember the trigger, repeat this phrase: for another, for a fee. If both are true, you need a license. And keep one more rule front of mind. A licensee may never pay or share compensation with an unlicensed person for licensed acts. So that referral fee to an unlicensed friend is strictly forbidden. If these licensing details feel like a lot right now, that's completely normal, and it's exactly why I created that practice question bank. Working through real licensing scenarios is the fastest way to turn this material into confidence. The questions are free, the link is in the description, and they mirror the Ohio State exam closely. Now let's tackle how you become licensed, starting with the salesperson. To qualify, you must be at least 18, hold a high school diploma or equivalent, and be honest, truthful, and of good reputation. A serious criminal history, especially fraud or real estate crime, can bar or delay licensure, though the division weighs the circumstances and rehabilitation. Every applicant must also submit to a criminal records check using fingerprints, run through both the State Bureau and the FBI. This fingerprint check is mandatory for everyone, whatever their history. And you'll need a sponsoring Ohio broker who certifies your honesty. So before you ever sit the exam, character, a clean check, and a broker matter. Here comes one of the most tested numbers on the entire state exam. An Ohio salesperson applicant must complete 120 hours of approved pre-licensing education before sitting the exam. 120 hours. Say it out loud. It must come from an approved provider, and the division won't process your application without proof. Those 120 hours split into 4 courses. 40 hours cover principles and practices. Another 40 cover Ohio real estate law, including civil rights, housing discrimination, and desegregation. 20 hours cover appraisal, and 20 cover finance. Always confirm the current course split, since Ohio recently updated these education requirements. Why these 4 courses? Together they teach real estate from 4 angles: how transactions work, the Ohio legal framework, including fair housing, how property is valued, and how deals are financed. One narrow exception: an applicant already admitted to practice law in Ohio skips the Ohio real estate law course but still completes the other 3. Becoming a broker asks more because a broker carries real legal weight. A broker candidate must have been licensed and active as a salesperson for at least 2 years, working about 30 hours weekly, and completed at least 20 transactions. The division tracks this with a point system, generally requiring 20 points. Genuine field experience comes first. On top of experience, a broker completes 4 30-hour broker-level courses: financial management, business law, human resource management, and applied business economics. These address the management side of running a brokerage. And note a recent update: a 2025 law removed the old college requirement, so these courses no longer need college credit. Always confirm current rules. One more broker concept the exam likes: a brokerage can operate as a sole proprietor or as a licensed entity, like a corporation, partnership, or limited liability company. Each brokerage must designate a principal broker responsible for compliance. If that principal broker's license lapses, the brokerage must name a replacement or stop operating. Now, the exam itself, given by a testing company called PSI, it has 2 parts: a national portion and an Ohio state portion. For the salesperson, the national portion has 80 scored questions and the state portion has 40. The exam is computer-based and graded immediately, so you'll know your result before leaving the testing center. The passing standards differ, so keep them straight. A salesperson must score 70% on each portion. A broker faces a higher bar, 75%, and here's a relief: you must pass both portions within a 12-month window. But if you pass one and fail the other, you keep the pass credit and retake only the failure. Let's return to that sponsoring broker, because the relationship is more than paperwork. A salesperson can be licensed with only one broker at a time and works under that broker's supervision. The broker certifies your character and commits to overseeing your work. Crucially, the broker is legally accountable for every affiliated salesperson's licensed actions. That's serious responsibility. Remember that mastering these numbers takes repetition, and that's where practice beats rereading. The free practice questions are built. Drill exactly these licensing figures until you can recall them under pressure. They turn passive watching into active, exam-ready skill. The link waits in the description whenever you're ready to test what you've learned so far. Our final major areas keeping your license alive: renewal, continuing education, post-licensing, and status changes. Start with renewal. Ohio ties your renewal schedule to your date of birth, so your license expires on your birthday in the renewal year. This birthday system spreads the workload. To renew, you pay the fee and certify your education. What happens if you miss the deadline? First a late fee and eventually your license lapses. A lapsed license can't be used for any licensed activity, and practicing on one is itself a violation. Reinstatement means paying fees and, depending how long it lapsed, possibly re-examining. So treat your renewal date as a hard deadline. Now, a number you absolutely must own. Every licensee must complete 30 hours of approved continuing education during each 3-year cycle, reported on or before your birthday at the cycle's end. 30 hours, 3 years, but not all 30 are free choice. 9 of those hours are mandatory specific courses, and the exam tests exactly which 9. Here are the 9 required hours, split into 3 equal parts. 3 hours cover civil rights and fair housing, including current local, state, and federal civil rights law. 3 hours cover core law, the current legislation affecting real estate, and 3 hours cover the Canons of Ethics. 3, 3, and 3, civil rights, core law, ethics. Brand new salespersons face one more requirement: separate from continuing education. A newly licensed salesperson must complete 20 classroom hours of post-licensing education within 12 months after the license is issued. 20 hours, 12 months. It covers practical topics like commercial real estate, property management, short sales, land contracts, contract law, and fiduciary responsibility. Real-world skills early. Don't confuse post-licensing with continuing education, because the exam will try to trip you. Post-licensing is a one-time requirement triggered by your first license and due within 12 months. Continuing education recurs 30 hours every 3 years for your whole career. The post-licensing clock starts the day your license issues, not when you start working. Your license can move among several statuses. Active means you're associated with a broker and able to practice. It's the only status in which you may perform licensed acts. Inactive means you're not practicing and your license is held with the division. Often when between brokers, you reactivate by completing required education and reassociating with a broker. 2 more statuses to know. A resigned license is voluntarily surrendered and out of your possession. Returning often means reapplying from scratch. Importantly, the division can refuse a resignation offer to dodge pending discipline, so you can't escape charges by quitting. Suspended is temporary discipline. Revoked terminates the license and forces a new application later. Here's a strict Ohio rule worth a guaranteed point. A salesperson may work for exactly one broker at a time, with no dual association. To switch brokers, you first end the current relationship, then reassociate your license with the new broker. During any gap, even a single day, you're inactive and cannot perform any licensed act. 2 special situations round out license status. Ohio law gives active duty service members and their spouses renewal extensions and expedited licensing, including pausing deadlines during deployment. And reciprocity lets licensees from certain states get licensed in Ohio, sometimes without full Ohio education or the state exam. A non-resident must file irrevocable consent to Ohio suit and service. Let's lock the maintenance numbers together. Think 30, 9, 20, 12. 30 continuing education hours every 3 years. 9 required, split 3, 3, and 3 across civil rights, core law, and ethics. 20 post-licensing hours for newcomers due within 12 months. Chant 30, 9, 20, 12, and the whole maintenance picture is ready for exam day. As we wrap up, remember that understanding these rules is only the first step. Real mastery comes from applying them again and again, which is where those free practice questions become invaluable. They're completely free. They cover everything we discussed today, and they're built specifically for Ohio State exam success. Grab them from the link below. Let's bring it together. You now know Commerce houses the division, the superintendent investigates and enforces, and the 5-member commission makes rules, adopts the canons of ethics, and hears appeals. You know discipline runs through notice, 30 days to request a hearing within 7 to 15 days, an order, and appeal to Common Pleas Court. You also know the recovery fund protects the public, caps at $40,000 per licensee, and suspends a licensee until repaid. A license takes 120 education hours, an exam passed at 70%, and a sponsoring broker, and maintenance means 30 continuing education hours every 3 years, plus 20 post-licensing hours within your first year. Take a breath. You've covered a lot today, and you should feel proud. These rules may feel heavy now, but with repetition they become second nature and predictable points. The students who pass aren't those who never struggle. They review and practice. Don't forget those free practice questions in the description. You've got this. Good luck.